Okay, good morning, good afternoon, whatever time it is. Welcome. My name is Anita Hoover, and I'm a member of your CNLA executive. Thank you for joining us today. Today, the risks and responsibilities of using labor agencies webinar was designed to provide information to members when hiring in Canada, with a focus on foreign workers. CNLA has hired immigration specialists, Zaifman Law, and we have Mira Thow and Ken Zaifman with us today to take us through this. Over the next hour, we will learn about temporary worker and foreign compliance, work permits, what they really allow and what to look for, what compliance under the temporary foreign worker program and the labor mobility program looks like, what happens in an audit inspection, what are the employer's rights when this happens, penalties and criminal offenses, what these can look like, hiring best practices for using staff agencies, what to ask for when using third-party contractors and subcontractors, and we will finish up with a bit on foreign recruitment. At the end, we want to provide some time for questions and answers. So at the bottom of your screen, or most likely at the bottom, you'll see a Q&A button. That's where if you have questions along the way, just type them in there and we'll queue them up to ask. So use the Q&A button for questions, and you'll see there's a chat button as well. There you can make comments along the way if you'd like. So, and at the end of the session, we'll go through as many of those questions as we can. So now I will hand the floor over to Mira and Ken. Thank you.
Good afternoon. I want to thank the Canadian Nursery and Landscape Association for giving me this opportunity to speak to you today. This is the second part of a workshop on risks and responsibilities relating to your foreign workforce. Whether you hire foreign workers directly or through a temporary staffing agency or through a subcontractor. The employer has a number of significant obligations. And you may have been told this if you were in attendance at the previous seminar, but really what happened was in 2014 and 2015, Canada brought in legislation and beefed up the provisions to enforce or put the onus on the employer to ensure that there is compliance, immigration compliance in terms of protecting the workforce, to ensure they have the proper working conditions, as well as to ensure that there are no unauthorized, no illegal workers on the job site. So one of the important things that I hope you take away from this seminar is if you fail to comply with these immigration requirements, there are serious both administrative penalties, and I'll go into later in my presentation on how significant they are, as well as criminal penalties that include fines and jails for violations. So the first thing you have to know is what is the makeup of your workforce and who is allowed to work legally in Canada. So basically there are four groups that are allowed to work in Canada. First, there are Canadian citizens. Then there are Canadian permanent residents who are allowed to work in Canada without any restrictions. Then the third category, which has two types of people, those are the temporary residents. And the only ones who can work for you are people with work permit holders. They actually hold a document that's been issued, a work permit, or in limited situations, certain study permit holders. Study permit holders are allowed to work 20 hours per week during the school term and full-time during school breaks. So that's who can be on your job site. Can you go to the next slide, Andrew? Thank you. So what you have to know about work permit holders. they can only issue, or immigration only issues work permits in one of two ways. Either under the International Mobility Program or under the Temporary Foreign Worker Program. And the difference between those two programs is as follows. Work permit holders who have gotten their work permit under the International Mobility Program do not have to have gotten a labor market impact assessment in advance. So the employer doesn't have to go to Service Canada, as we colloquially call it, ESDC, to get approval from Service Canada that there are no Canadians available for the position. And those types of foreign nationals who hold work permits under the International Mobility Program will hold two types of work permits. They can either be open work permits. Open means there's no restriction on who the employer is. So if the work permit will say on it, it's open, it will allow that worker to work for any employer. Another type of work permit that can be issued is the employer-specific work permit. And those work permits have a specific employer name on it. So I've given in my paper, you can see the types of workers that you might be able to get on open work permits. So you might have on your workforce spouses of skilled workers, they get open work permits, spouses of foreign students, applicants whose permanent resident application is in process. While it's in process, they can have an open work permit. Certain refugees at a certain stage, they can get open work permits. And then there are some special programs, I haven't mentioned all of them. One of them that may come up in your industry are people under the International Experience Class, the working holiday for younger workers. Then the types of work permits that you may see that are employer specific, but that didn't require the labor market impact assessment, those are generally special high skilled workers. They're workers that may come under an international treaty like CUSMA, which was the old NAFTA, the North American Free Trade Agreement with Mexico, certain intra-company transferees, certain persons that are under provincial nominee programs. So each province has rules and guidelines allowing them to select workers or to select permanent residents. And in those programs, certain work permits can be issued. Now, the other type of work permit holder is someone under the Temporary Foreign Worker Program. And there, the employer would have done a lot of work up front because they would have had to have gone to Service Canada to get a labor market impact assessment approved. And that would have involved advertising in most cases, unless there's a special exemption. There's a set of criteria, which is a real other whole workshop on how to apply for a labor market impact assessment. But you'll know, because you'll have been through that assessment, you'll have convinced a Service Canada officer that your industry has a shortage of workers because you've done all of these steps to establish that there's a shortage of workers, and then you'll be issued a labor market impact assessment. And with that labor LMIA, the foreign worker that you've selected can come to Canada and is issued a work permit. Now, work permits that are issued pursuant to with an LMIA are always employer specific. So one of the interesting points that was raised in the previous seminar was where you're using a temporary staffing agency. You're not going to see a work permit issued to a temporary staffing agency that allows a worker to work anywhere, because the temporary staffing agency has to be the employer in order for Service Canada to have issued the work permit or issued the LMIA, which is the basis of the work permit. So if you could go to the next slide, Andrew. So you're going to have in your workforce people who either you obtained LMIAs for under the Temporary Foreign Worker Program, or another way, if you've hired them directly, who are holding work permits under the IMP, the International Mobility Program, which can include the open work permit holders. So in those cases, there are immigration compliance requirements that are related to working conditions of the foreign worker that every employer has to comply with. And they're very similar under either program. I've put the temporary foreign worker program requirements first, and they're set out in the document that will be issued to you, the LMIA. You'll see them all written down there. And so this is a summary of the important ones. The employer has to, first of all, make sure that they're complying with all provincial territorial employment laws and recruitment laws. So that's important to know because different provinces have different requirements on hiring of foreign workers. The employer may have to register under the provincial legislation in order to have a foreign worker, in addition to getting the LMIA. So that's one step that if you're going to go this route to directly hire an employee, a foreign worker, you're going to have to also check out the legislation in your province to see whether you can register. In Manitoba, for example, it's a simple process. It's a simple form. You register, and that just puts you on the radar to ensure that their Employment Standards Branch is aware that you are hiring foreign workers, and they want to be sure that you're not charging recruitment fees to the worker. So that's one of the main reasons why the provincial legislation is there, to protect the foreign workers from fees. The other thing that you have to ensure is a workplace that is free of abuse. So every workplace should have a policy in their HR manual, and that's preferably posted, that provides employees with avenues or resources to contact should they believe that they're suffering or they've encountered any abuse. You have to provide the foreign worker with the actual job and duties you said in your LMIA you were going to hire them for. You have to pay them the same wages that you said you were going to hire them for. So you can't advertise and get an LMIA to pay someone, for example, a salary, and then when they get on your site, you decide to pay them on a piecework basis, or you can't hire them on with an LMIA that says you're going to pay them $20 an hour, and then when they get on your site, you only pay them $15 an hour. That's a serious violation. The law says the wages must remain substantially the same and not less favorable, but we know from experience substantially the same has been interpreted as very narrow. Almost any kind of change in the salary is a violation or will be considered a non-compliance. So if you're going to change the salary and you didn't disclose ahead of time in the LMIA that you were going to raise the wage for whatever reason, or lower the wage, you're going to have a violation, and you have to either notify Service Canada before you do it, and likely you'll have to get a new work permit and start afresh. Now, the next one is, again, not only is it a provincial requirement, it's also a federal requirement not to charge recruitment fees, and not, if you're using a third party to help you prepare the labor market impact assessment or to recruit for you, and they're charging a fee, that's illegal, and you can't recover fees from the foreign worker that you may have paid to that third party or to the recruiter. So if you've had to pay the third party agency for every employee that they make available, you can't later on try to recover that somehow from the foreign worker. Of course, all the information you provide in connection with your labor market impact assessment has to be accurate. Now, one of the important things is that you have to maintain documentation to show that you are in compliance with all these rules for 6 years from the first date that the foreign worker starts his employment. And so that's why every HR or every company should identify an individual in their company who will keep a file that will show that they have complied with everything. And the type of documents they're going to want to see are the payroll records, the timesheets, of course, copies of the work permit. And you have to keep them so that when you're audited, and you can be audited or inspected within any time within that 6-year period, to make sure you have the file with all the documents. Of course, that file should be kept separate from the personnel file, because you're going to have to hand that file over to Cbsa when they do their audit or inspection. And the other requirement is to assist with audits and site inspections, including interviews and productions of documents. So you are under an obligation by the issuance of the LMIA, and it's listed right there. You'll have to sign that you accept these conditions, and you have to be available and cooperate with audits and site inspections. Andrew, can you go to the next slide? Now, compliance under the IMP, I'm not going to go through it because it's almost exactly the same. It's just not written down on a labor market impact assessment document. So you have to, it's imposed on you in the legislation. The difference is, instead of an LMIA, you go online, you have to register your company on the IRCC portal, which is a simple thing to do. You just need your CRA number, you put it in, you become registered, and then you can use that portal for filing. We call it an offer of employment, but it's actually a portal form in which there are 4 sections that relate to working conditions: the wages, the salary, and the name of the foreign worker, their identifying documents. So that information, the law says that you put in on that offer of employment has to be accurate. And the only fee that you pay is the $230 employer compliance fee. And when you upload that on the portal and you pay the fee, an A number, a number is issued beginning with the letter A, and that's how you know that the offer of employment has been accepted. And that A number is given to the worker, and that's how the worker gets their work permit, because they need that A number. And again, the same obligation to keep your documents to show that you're in compliance with all of the working conditions, all of the salary and wage requirements for 6 years, and the same requirements for audits and site inspections to turn over those documents and to cooperate. Okay, Andrew, the next slide, please. So for audit and inspections, you may have heard the Cbsa representative in the previous workshop, where he indicated that he is in plain clothes and he can attend at your site. There are basically 3 ways that a Cbsa officer will identify your company for an audit. One is where they have reason to suspect from a tip or a complaint that you may be in violation. The second is if you've had a history of previous non-compliance. And then what wasn't stressed is the random selection. And that is, there's a policy now that the government has advised us that they will randomly select 25% of all companies randomly. And in our practice, we've had large and small employers. We've had crown corporations, we've had large multinational companies, and we've had small businesses. So there is no exemption to anybody. It's just a random selection, and it's happening quite regularly, at least 25% of every employer. And you're on their system because you've either gotten an LMIA or you're the employer on the work permit. So they have on their system your company's name and your CRA number, and that's how they connect and with the job site. The employer rights and obligations, if you are randomly selected or someone visits you. Now, it can happen in 2 ways. They can actually show up at your job site without a warning, or generally in a random selection, you'll get an email or a phone call first, and you'll be told and given an opportunity to provide the documentation to prove that the workers are that you're in compliance with all the workers that they are concerned about. So When you're notified that there's going to be a audit or an inspection, you have the right to know the reason for the inspection. When it's done in writing in advance, it'll say right on the document, you have been randomly selected. It'll say the reason why. And in those kinds of situations, and even when the officer appears in person at your job site without warning, you do have the right to ask for counsel, to seek representation, and to ask for an extension of time to respond. Many times you may keep the files on a different job site from where the individual, where the Cbsa officer has turned up. So you have the right to a reasonable extension of time. Generally, they give 15 days. That hasn't been a problem. And in certain circumstances, especially in COVID, other more lengthy extensions can be requested. And as I said before, the types of documents they're going to ask you to produce will include payroll records, timesheets, check deposits. They're going to want to see that the check for payment to the employee has been cashed. So it's not enough just to show a copy of the check issued. You're going to have to show that it was cashed through the employees, either if it's a direct deposit or through their checking account. And they ask you then to black out some of the important identifying information. Next slide, please, Andrew. So as I said at the beginning of the presentation, there are significant penalties, both administrative penalties and criminal penalties. So the penalties that are administrative under the compliance regime for violating any of the terms in your LMIA or under the IMP program include warning letters, but they include fines ranging from $500 to $100,000 per violation. And you can have many violations and many workers who are all not in non-compliance for each worker, and you're going to have a separate violation for each, up to an annual maximum of $1 million. So that's quite serious, and that's why there is a way to notify IRCC in advance with a voluntary disclosure. If you know you're in non-compliance, the wages have increased and you forgot to, and you didn't realize that, you can voluntarily disclose changes. And if you disclose them before they've audited you, that will be a factor when they decide. There's a point system on how they decide the severity of the non-compliance, and that will affect your fine. Of course, also you can face a ban on hiring workers in the future. They can revoke the LMIA and the work permit. And they have a government website where the business can be posted as being a violator. So that is pretty strong administrative penalties. Now, what we've been talking about up to now is primarily where you're hiring directly, whether under the Temporary Foreign Worker Program or the IMP. But the Immigration Act also imposes an obligation on employers not to hire illegal workers. And they make it a criminal offense to employ a foreign national who is not authorized to work. Now, most criminal offenses require knowledge. An employer who didn't know could say in most criminal legislation, you can't convict me, I didn't know. Well, this is such a serious offense that they put in a section that said, you are deemed to know that the person is there illegally unless you exercised all due diligence. So their legislation is putting an onus on each employer to exercise due diligence. So in this seminar, often people say, well, have we done our due diligence? And that's sort of generally thought of as maybe just extra steps you want to take, but not in the criminal realm where you will be convicted and face penalties. There's fines and jail if you don't do your due diligence and immigration determines that you have unlawful, illegal workers. So those are workers who are not Canadian citizens, workers who are not permanent residents, workers who do not have a work permit, workers who have a work permit, but it's either not valid or it's not specific to your job site or to your company, if it's in someone else's name, unless it's an open work permit, or you're hiring a student outside those limited rules. So though any of those types of people, if you're not in compliance, you are deemed to have violated the law unless you exercised all due diligence. And then another offense is in aiding. It's an offense even to aid others. So if you aided or were willfully blind to a third party helping someone to work illegally, that's also an offense. So in the face of all of those compliance requirements and all of the criminal sanctions that you face, we think that now you better do your due diligence, and Ken is going to set out for you a list of steps, a list of tips that you should take in order to be able to manage your risk in these situations.
Oh, thank you, Mira. Andrew, next slide, please. So as Mira explained, all foreign workers must have a work permit that authorizes the foreign worker to work for an employer at the location where they are working in the occupation listed for the duration on their work permit. So most employers, and this is not typical of this association, are faced with the dilemma of trying to find workers to fulfill its contractual commitments to customers and clients. It's usually not a factor of getting the work, it's doing the work. So those who have hired directly have found it necessary to supplement their staffing by hiring staffing agencies. So it's quite clear that an employer using the services of a staffing agency as part of its workforce is not exempt from the requirements that ensure those workers can work. And it is not uncommon for staffing agencies to fail to disclose the nature of the workers that they have working for them. So we got to remember, LMIA work permits are not issued to staffing agencies. So if you have gone through a process to hire workers directly, those workers will have work permits issued in the name of the employer. Mira has explained to you if you're found to have foreign workers on site without proper authorization. And I can't underscore the fact that employers cannot hide behind a staffing agency. And it's quite clear in the legislation and in practice that this will not particularly assist them. Andrew, next slide, please. So the heading is best practices on using staffing agencies for foreign workers. So I put the little notation, don't. Now, the reason that I start from that premise is that staffing agencies can cast a wide net in terms of finding workers. And they, from time to time, don't do the checks that they're required to do because they're under a contractual obligation or some other obligation to provide workers to an end user. But, you know, what do you mean, or what is meant by the term due diligence? And so I'm going to try to sort of distill it to some basic concepts. If you're using a staffing agency and they provide you with a worker, a copy of that worker's Canadian or permanent resident status document before they commence employment. For a foreign worker, a copy of the work permit and their passport identification with social insurance number. These documents are not difficult for staffing agencies to obtain and is really a prerequisite for any kind of relationship you have with them. The simple and fact of the matter is staffing agencies have to provide you with documented workers, not undocumented workers, or not workers that whose documentation is suspect in some way. So what is an employer required to do with a staffing agency? Well, the agreement with the staffing agent should clearly state that they will provide an employee who's legally authorized to work in Canada for your company at sites in the province where the worker will be assigned. To not assign the worker prior to confirming that the employee is legally authorized to work. That the staffing agency shall complete and maintain all work permits, visas, and be responsible for complying with all Canadian immigration laws and regulations. Now, sometimes individuals are on work permits and those work permits expire. However, that does not necessarily mean that the worker cannot legally work if the staffing agency or the worker has applied for an extension of that work permit on a basis that makes that worker eligible to apply for an extension. Copies of a Canadian permanent resident status documents are commonly available, and they should ensure that they have that. And perhaps the most important, or one of the most important, to confirm that the staffing agency has not charged the foreign worker a fee, directly or indirectly, to obtain employment. And there are many instances where staffing agencies have used a contract with an end user to charge workers a fee, and some of those fees are substantial. And I want to underscore one little point that, as I said in this slide, there is a case currently before the British Columbia courts where Max convenience stores hired a third party to recruit workers. And the third party provided the employer with, I would say, a fairly under market price for recruiting workers. And how were they able to do that? Because they were charging the worker a substantial fee. In this case, maybe $6,000, $8,000 to work at a Max convenience store. Some of those workers got together and they sued Max Convenience based on a class action. And if any of you have been involved with lawyers, you know the words litigation, enforcement, criminal charges have a significant economic impact. So it's very important to confirm the staffing agency has not charged the worker a fee. So if someone comes to you with an offer that they can provide you workers at a great price, you've got to be a bit suspect about that, because there's a cost to recruiting foreign workers. And if they're offering the employer a good deal, they're probably charging the worker. I shouldn't say probably, there's a likelihood they're charging a worker for that job. Next slide, please. Now, third-party contractors and subcontractors are really people that the employer hires to provide services. And the same exercise in due diligence applies. Because if you're hiring a contractor, let's say to do a specific job for a client, perhaps you're bringing in some specialized piece of equipment, or you're doing some additional work other than maybe paving or whatever you need to do as part of the contract, and you hire a company to do that, you still are obligated to ensure that the workers on your site are legally authorized to work. And so the items that I've spoken to you about earlier with respect to staffing agencies applies as well. So you've got to recognize that not all staffing agencies and not all contractors are intent on not adhering to the law, but they face in some ways the same problem that you do, is finding workers. And their net may be broader than your net, but they face the same dilemma. If you could find workers directly, that's probably the better way to go. In terms of clauses with third-party contractors, there's some language on the slide, which basically gets the contractor to confirm that the workers they're providing to you are legally authorized to work. Now, that doesn't shield you from compliance issues, but it certainly goes, a step in ensuring due diligence. And again, you have to find a mechanism where the contractor provides you with notice in writing of who the names of the foreign nationals are, that they're legally able to work, and whatever work permits and passport identification that they have. So that's a very critical and important step in the process. Next slide, please. I want to take a minute to talk to you about foreign recruitment. And I can tell you part of what our firm does through a different company is it recruits foreign workers for a number of industries in Canada and in various provinces in Canada. It is always, in my view, better for an employer to deal with labor shortages by directly being involved in the foreign recruitment process. It is more work, somewhat. It has more cost, but it provides the employer with a workforce that it has determined is both qualified and legally able to work. And the recruitment of foreign nationals is regulated in a number of provinces, particularly in Manitoba, Saskatchewan, Alberta, and British Columbia, under what is called in Manitoba Workmen Recruitment and Protection Act. And I'll use that as an example for a moment, where a recruiter to be licensed under that legislation has to be either a lawyer or a licensed immigration consultant. They have to meet the requirements of that piece of legislation. They have to have an insurance and have a bond with that province in various forms, and they have to undertake on their behalf and on behalf of the employer that recruiters will not charge a fee. And that is a critical piece of this puzzle, because many workers who have gone to various provinces have been charged fees, and the fees can be quite significant. And I can tell you that just as early as last week, Cbsa rated a number of consultants and some employers in a certain industry where the fees charged to workers were $30,000 to $40,000 per job. So the money is staggering, and the consequences to employers, I think, will be significant. So recruiters can charge their fees to an employer, and that is really what employers should really take stock of. What is the scope of services that the recruiter will provide? And because you use a licensed recruiter does not absolve the employer from due diligence or ensuring that no fee was paid by the worker. But most licensed recruiters will provide employers with a very clear scope of services and very clear language that workers are not being charged a fee. and I'll give you another example. In the Philippines, the recruitment of foreign workers is regulated by the government of the Philippines. And there are very strict requirements and strict penalties for recruiting agencies in the Philippines and elsewhere for charging workers a fee. Next slide. So I've left a fair bit of time for questions. I do want to, as we're going through the questions, I just want to make sort of a general observation. It has been my experience that employers are not looking for ways to circumvent legislation. They don't go start the morning day saying, well, how can we avoid complying with the immigration requirements? Their main problem is finding a secure, committed workforce. And in order to do that and to grow your business, I think the inevitable conclusion that employers that we work with have come to have drawn is they've got to do direct hiring, and this way they can be responsible for the workers themselves. There's no question there's additional obligations. There's recruitment costs. There's perhaps relocation expenses. There is ensuring that workers have a place to live. There's a whole host of issues. But if you decide to go down this road, you will find that your business will have a very stable workforce. And again, I'll cite just in passing experience with a food processor based in rural Manitoba who started life 10 years ago with 150 employees and now is at 1,500 plus sales in the range of hundreds of millions of dollars. Primarily, that growth was funded through foreign recruitment. And other companies, smaller ones, are finding the same equation applies. The issue for us and in our practice is, and Mira has pointed out, and I, from a more practical perspective, is that the needs of employers in terms of finding a stable workforce are not going to subside regardless of what the unemployment rate is and what the current economic climate is. The work is there. The companies that we work with can get more work. But the issue is, how do they fulfill their obligations to their clients? So I think I'll leave it off for that and take your questions, unless Mira wants to correct me if I've made any mistakes.
All right, well, thank you, Ken and Mira, for your informative presentations and for everybody that's participating today. So for the questions, if you've got more questions, we've got some queued up in the Q&A. So if you have your questions, type them in the Q&A and I will read them out, and whoever, Mira or Ken, whoever wants to take that question, I'll let you go for it from there. So first we've got, for a study permit holder, how can we verify that they are on a break from their studies and can work over 20 hours? What's the credentials they need? Well,
you know, that's a very good question. So the first question, and it's not an easy question to answer. Well, the first question is, are they enrolled in a program of studies? Get some confirmation that they're enrolled in a program of studies, because their study permit and their ability to work is tied to being enrolled in a program of studies. One issue that has come up is where someone graduates from a program of studies, from a designated learning institution in Canada, they're eligible for something called a postgraduate work permit. So a student who has graduated from a program of studies can apply for an open work permit. So you may have some individuals who are working for you in a break on a study permit, and then have applied for a postgraduate work permit, which gives them authorization to work. I think, the question is, are they studying? Where are they studying? Are they going back to school? Are sort of sample questions you can ask. And I think that, could be sufficient if they provide you with their registration or some piece of paper that says they're engaged in full-time studies.
All right, thank you. So in all cases, can it be categorically said that the Government of Canada never issues LMIAs to staffing agencies?
Well, the short answer and the long answer is government policy is that they don't, and they're not supposed to. We have seen where sometimes that particular prohibition has been eroded somewhat because of the way the LMIA was submitted. But as a general rule, I think it's better to assume that an LMIA is not issued to a staffing agency to take that worker downstream to another employer.
All right, so next was a comment about sending out the clause that we should add to our subcontracts. So I think you had kind of a sample and the in the presentation here, but can we send out a clause, the wording of a clause that should be added to subcontracts?
Yes, so the association has our authorization to distribute the paper with the clause that was shown. And this will be recorded, so you'll be able to actually read the paper or listen to our comments again. So yes, that will be distributed, and if you just contact BCNLA, they'll provide it to you.
Perfect. Okay. So next question is, how do we know if the foreign national is the right fit for the job, reliable, hard worker? So it's not the same as interviewing somebody face to face.
I think the question is, are you allowed to assess a worker's skill before actually giving him an offer of employment? And this is a very, very difficult issue, especially if you're dealing with temporary foreign workers or staffing agencies. As a general rule, you wouldn't necessarily ask someone to do some of the job that you want them to do before offering them a position. I think the interview process is critical. If it is somewhat standard in the industry to assess someone's skill before you actually offer them employment, whether that's a Canadian or a permanent resident, if you follow the same process and you have them, work for an hour or do something so you can assess his skill level, that's probably acceptable. If you have them assess his skill level over a longer period of time, days, I would say that probably is not. But I think it's important that a temporary foreign worker does not gain more rights than a domestic worker. They can be terminated for cause. The usual remedies are available to employers. But I think it's important that you don't want to appear that you're having the temporary foreign worker work while you're assessing his skills for some prolonged period of time. Everyone knows, in your industry, what you need to look at and consider. So, if a staffing agency is giving you a worker and say, why don't you try him out for a week? I don't think you should. That's certainly not consistent with the legislation.
Okay. So next, I have a landscape management company and I have a potential employee asking me to complete the LMI for him. My work is seasonal, about 9 months, as we can't work in the winter. Is there any chance I can get an LMIA approved for him?
Well, I'll let Mira start with that, and then I'll.
Well, it depends what the job is that you're hiring him to do, because under the LMIA process, it's a complicated process, but it's divided into high-skill jobs and low-skill jobs. There are certain types of jobs you can do that are seasonal, and they have special criteria for seasonality, but it depends on the specific job. So on the first presentation, they gave you the resource. You can go on a website, on the IRCC website, and they'll go through all the requirements of the LMIA, but it's very complicated. And I would advise that you get legal assistance, at least for the first one. Once you've done one LMIA, you'll see what the requirements are and what you have to do, and whether it's worthwhile, and it may be something that you're going to want to do then for a larger group of employees. But in order to answer on this, in this format, unfortunately, I can't tell you exactly what you can do. We're going to have to assess exactly what the occupation is, under what category, but certainly an LMIA may very well be there. But there's certain categories in the landscaping field where they will not allow LMIAs for. So, it may be a good avenue for you, but you have to really explore it, and you should contact someone who is adept and who's knowledgeable in the area to get you started.
All right. So next question, is it harder to get a permit for people from, in this instance, a communist country?
Well, I would say that the applying for a work permit, whether you've got an LMIA in place or not, will depend to a certain extent from where the applicant is applying from. And the determination that an immigration officer makes outside of Canada in assessing whether to issue a work permit is, will this individual return to their country of origin after their work permit expires? This is very much this is a interesting and difficult question, and it's cyclical. There's nothing, it's not whether it's communist or not. And I can tell you early on in the foreign recruitment work we did in the Philippines, the visa office in the Philippines was very reluctant to issue work permits on the scale that we were asking for, because they were of the view that the workers would not return to the Philippines after their work permit expired. And we had to make representations to the visa office to say the whole purpose of the temporary foreign worker program, and these were workers destined to Manitoba, was that they transition from temporary to permanent. And depending on the province that the worker is destined to, there are programs where temporary foreign workers can transition to permanent residence, which is what you want. You want a permanent worker, not a temporary worker. So it's not a question of it's communist or not. It's a question of what the attitude of the visa office is. And if you can provide them with clear and convincing details that the worker either is only going to be there for a temporary purpose, has ties to his home country, or can transition to become a permanent resident, that issue is largely subsided over the years.
Okay, so I think this next question probably depends on the situation as well. So what happens if the individual has limited English but a good education? Do you have to speak English to get a work
Well,
permit?
Mira will speak to the LMIA for a moment, and I'll just go over that after she gives you that.
Well, it's going to depend again on the occupation. There's certain occupations, the level of English, and when you deal with an LMIA, you have to advertise first in Canada to show there are Canadians available, and you have to indicate that language, they have to have at least English or French. So then when the LMIA is approved, unless you're in some occupation like translators or a strange occupation, the job is going to require language skills. Now, depending, and will require either English or French. Now, the level of the skill will vary depending on which program, LMIA program, low or high skilled, or whether it's part of a transitioning under the provincial nominee program, which has other more lenient requirements in terms of the level of English. And Ken What's your experience with that?
Well, I think Mira is quite right. I think the issue becomes one of ability to work in the workplace and a health and safety, following directions. And it varies from, I wish I could give you a more concrete answer. It varies from visa office to visa office, and sometimes from visa officer or border service officer to another. Generally, if the applicant can communicate in English at a certain level, as part of the LMIA, they have to have the ability to communicate. If they can speak no English, that could be an issue because they can't communicate, they can't deal with workplace safety issues, and they may not, be issued a work permit. It just depends on the occupation and on the officer assessing the application.
Okay. So we've got this question next, and I see it's on here again. So are we permitted to ask for a copy of the social insurance number and other documents for our files for workers who are placed through a temporary helper agency? So if you have temporary workers, yeah.
Oh, sorry. First of all, you can ask for that document, but it's not the social insurance number that will be sufficient for your due diligence. A social insurance number doesn't mean they have, at that point, actual ability to work. They could have gotten a social insurance number to work for a different employer. They may no longer have a valid work permit. The fact the social insurance number doesn't automatically get revoked if they're no longer in status. So that's not the document that is critical. The document that you should be asking for and that you're legally entitled to ask for is, for a Canadian citizen, proof of their Canadian citizenship. So that's either their birth certificate in Canada or their passport or certificate of citizenship if they were born outside of Canada. For permanent residents, you ask for their PR card or their confirmation of permanent residence. And for workers, foreign workers, you ask for their work permit. And then you should also ask for a copy of their passport page so that you know that you're not dealing with someone who's given you a fraudulent document. You want to make sure the work permit is in the name of the same person whose passport you've been given. So just the photo ID, the page with the photo ID on their passport and a copy of their work permit. Then when you have that, you should also ask for their social insurance number. It's sort of a secondary document. If they're a temporary worker, they'll have a number that begins with 9. But other than that, I mean, the social insurance number isn't the number that gives you confidence that they are not illegal. They could have been issued a social insurance number at any time and still be out of status and still not be able to work in Canada.
So just to be clear, so even if you're not the direct employer, if it's a third party or a hiring agency, you still can ask for that work permit.
Because the obligation goes to the person in Canada or the company in Canada that is benefiting from the services. Even if you are not paying that employee directly, whether the contractor is paying it or the third party staffing agency is paying it, or you're paying it, but you got them through the staffing agency, doesn't matter who paid for or is paying their salary. If they are on your site providing services to benefit your company, you are responsible.
All right. So next we have, if a work permit holder is applying to extend or change their visa from, let's say, for example, a work permit to permanent residency, and are told the implied status allows them to continue on their current work permit, how can one confirm that this is true and how long is that valid?
Well, the simple answer is that if they've applied for an extension of their work permit, they would have filed an application with IRCC prior to the expiry of the work permit. And asking for a copy of what they filed is the way to confirm that they've actually filed the extension prior to the expiration of their work permit. So with that filing, that gives them implied status, which is legal status in Canada to work. And I think that probably would be sufficient as part of the due diligence, because I don't think, because there are various nuances in how you apply for an extension of your of status, and it can be quite complicated, and is even a little more complicated because of the public policy provisions put in place because of COVID. But if an employee comes to you with a work permit that's expired, and it's an open work permit, not a closed work permit, and they've applied for an extension, they would have a copy of what they filed prior to the expiration of that work permit, and you should just ask for the paper. And if a staffing agency has done it, then you should maybe go a little further to confirm that it's actually been sent, whether it's online or through some other means.
And now online, when it's filed, an acknowledgement of receipt, it generates within 24 hours. And now there is a line on that acknowledgement of receipt. If you ask for proof that it's been filed, the document that's generated says right in it, you have implied status until a decision is made. So they've started to do that. So you'll see right on the document. But if you have proof that they filed, they have implied status, and you can then provide that document if they need to update their driver's license or their insurance. Each province should recognize the implied status, and we haven't had a problem in Manitoba with that.
Okay, so we just have, we're kind of at our time, but we have just 2 more questions. So if everybody's okay, we'll just try and, oh, another one popped on there.
Well, let's keep going. Let's keep going.
Yeah, okay. Okay, so if the criteria for the LMIA is different in each province, is it best to engage an immigration lawyer from the province we operate in?
Well, I mean, I'll just give you our example. We do work for employers in all provinces, and many law firms do that. I don't think it's really dependent on the province, as long as you know the general LMIA rules and you have the experience to satisfy a client, that you can do an adequate job of representing them. You don't actually have to be in that province. I would just usually caution employers that they should at least ask the question of the types of applications the law firm has done, and can they do this work, and have they done it before? But we're not restricted provincially to where we do the work.
Okay. So in verifying all that we have discussed here, you find that you have an undocumented worker within your employment. What are you required to do in order to protect the worker and your business?
Well, to protect the worker and to protect you are sort of slightly different questions. To protect you, you have to terminate the worker. To protect the worker, the question is, why is he working for you in an undocumented way? And is he using a staffing agency? Has he paid a fee? And I think then there are options open to workers. So let's use a scenario where they paid a fee to a third party. They don't have the proper documentation, and then you find out that they have. They don't have legal authorization to work. I'm very reluctant for employers to become, immigration lawyers and consultants helping their workers. It creates a whole host of liabilities that you don't want to take on. But you can refer those workers. There are agencies in each province that will help workers. There are government programs. There is what's called the Vulnerable Worker Work Permit application, which allows workers who've been abused by employers to apply for an open work permit. And there are remedies for the worker. So I would direct that worker to an agency that could help them. But I think the unfortunate reality is that if they're undocumented and you find out about that, you have to terminate that worker. Otherwise, you then, if you maintain his employment, are leaving you open to some liability.
Oh, unmute.
Sorry. Can an employee obtain status while in Canada already? So I guess if they're, I'm assuming they're asking if they're not legal in Canada. Can they?
Well, there's two answers. If they have legal status or on a work permit, there is a process where they can apply for permanent residence, and it varies. There's different provincial programs. If they don't have status, and you want to help that undocumented worker, there are ways for them to apply for legal status. They may have to apply outside of Canada. They may have to leave Canada, and then you bring them back with the proper documentation. So the only real prohibition against an undocumented worker from coming back to Canada on a work permit is if they've worked without authorization. There's like a 6-month bar that they can't apply for a new work permit. But there are workers who've been in Canada either legally or undocumented, and then who've come back as workers and are now permanent residents. So there is a process. Not always easy, but there is a process.
Okay. Well, thank you. That was fast and furious questions coming at you. So, Andrew, if you can put up the last slide again with the contact info. There we go. And just want to thank both you, Mira and Ken, for all your information and your work putting this together. It was very informative, and I was writing notes as you went of all the things that now I need to look at in my own organization. And thank you everybody that joined us today. So for everybody's information, as was mentioned, the webinar is going to be recorded and you can rewatch it later. It will be available on the CNLA, Landscape Ontario, and probably possibly other provincial sites. So thank you everybody, and have a great day and a great spring.
Well, thank you for inviting us and giving us the opportunity to present to your organization.
All right, thank you.